I've just been waiting for the numbers to plateau. I think we might be there. So good afternoon, everyone, and welcome to day 3 of ICC UK's annual Arbitration and ADR conference. I hope you've been able to participate in some of the other events, but I'm sure this one will be the best, of course. Today's session, or this session, is going to be discussing Arbitration Act reform. I only have one job, which is to introduce James, our moderator, which I'll do in a moment. In the meantime, just one thing to mention, hopefully in your functions, you will see a chat function and a Q&A. Whilst James and the speakers discuss the topics, you're welcome to put the Q&A questions in the Q&A as you go. There is also a chat function as well, but I'd encourage you to use the Q&A because that's where we will be picking questions for our speakers. So allow me now to introduce James Freeman. I'm sure you all know James. He's a partner at Allen & Overy and is also a member of the ICC UK Arbitration and ADR Committee. James, over to you.
Thank you very much, Guy, and welcome everybody to this second webinar on the third day of the ICC's annual Arbitration and ADR conference this year. I've got the easy bit. I'm moderating this discussion, which will be on the reforms that have been proposed to the Arbitration Act by the Law Commission in its very timely report that it published just in time for this webinar. So many thanks to the Law Commission for that. On the panel, we have 4 very qualified and speakers who I think will provide a diverse range of perspectives on the subject. So we have Jelita Pandjaitan, who's a partner at Linklaters and based in Singapore and the head of Litigation, Arbitration and Investigations for Linklaters in that region. And we have Costa Frangeskides, a partner at the Wordley partnership, and I think one of our sponsors today. So thank you, Costas. Thirdly, Chantal du Toit, senior legal counsel at Shell. I think Chantal is currently based in Houston, so special thanks, Chantal, for getting out of bed for us this morning. And finally, and I've deliberately left Nathan to last because I think he deserves a bit more of an introduction. Nathan, who is a lawyer in the commercial and common law team at the Law Commission, has performed the heroic task of accommodating and taking into account and listening patiently to what must have been a deluge of consultation responses to the Law Commission's 2 consultation papers, and is now justifying and explaining the reforms that have been proposed, not only in this forum, but in various others in recent weeks and weeks to come. So thank you very much, Nathan, for taking your time again to explain your work and respond to hopefully the comments and views that we'll hear both from our panelists and to those of you who've joined us. I'd really encourage all of you to chip in on the chat function. We want to make this as interactive as we can for the webinar function. We've only got an hour, so we're not going to do justice to the whole of the Law Commission's report. We're going to try and do reasonable justice to 4 of the topics that were considered for reform by the Law Commission in its process. Those are, first, the question of the law applicable to the arbitration agreement. Secondly, the process under Section 67 of the Act for considering challenges to awards on the basis that the tribunal lacked jurisdiction. Thirdly, the proposed new process for summary disposal. And fourthly, the question of confidentiality, which differs from the other 3 in that confidentiality is a subject where the Law Commission chose chose to recommend not to legislate. Whether we have time to get through all of those, we'll see. Depends how many questions you have, and hopefully we'll end with a wrap up to consider where the process goes from now. You don't want to hear any more from me. Let's actually get on to the substance of the matter. And our first topic is the question of the law applicable to the arbitration agreement. And in each topic, I'm going to ask Nathan to kick off by describing what the Law Commission has recommended in its report, and perhaps also, Nathan, briefly, why. So over to you.
So on governing law, we have recommended that the law applicable to the arbitration agreement will be the law of the seat, unless the parties expressly agree otherwise. And choosing a governing law for the matrix contract isn't enough. We think that this will provide a clear and certain rule for most cases. Importantly, it also means that where an arbitration is seated in London, the arbitration agreement will be fully supported by English law. Back to you, James.
Thank you, Nathan. So to kick things off, Chantal, what do you make of that?
James, thank you for having me firstly, and I think Nathan will be delighted to hear that I agree with him on this one. You know, James, I think from a user's perspective, it actually really does matter to have this clarification. There are a couple of reasons for that. The first one is I think it more closely aligns with user expectations. You know, what we see in contractual negotiations is, of course, counterparties very often pushing for the local law to govern the matrix contract. And in many instances, that probably makes sense because it's governing the substantive rights and obligations under the contract. But in many instances, that law is really wholly unsuitable to be the law that governs the arbitration agreement. For example, it may not be favorable on the question of arbitrability or separability. The local law may never have turned their mind to the question of those concepts. And so, you know, I can only speak for myself, but I really think that aligning the law of the seat with the arbitration agreement is really much more in line with the expectations that I certainly had as a user. You know, for me, when I looked at Anchor and Chubb, that was a departure from that and not a welcomed one. And so I think in aligning the governing law with the seat, really what the Law Commission have done is to adopt a much safer and more predictable outcome, provided, of course, you're comfortable with the law of the seat being the law that governs your arbitration agreement, right? That's a step and a check that you'll need to take. The other thing, of course, with this is that you're avoiding that satellite argument being taken about some of the concepts that I mentioned, arbitrability, etc. And those sort of jurisdiction challenges can be incredibly time consuming, very costly. And of course, as a user, that is really what my lens is focused on, trying to resolve the dispute in the most efficient way. And so I really see that this clarification lends itself to that.
Thanks, Chantal. And so just to follow up on that, so currently in the law as it is under Anchor and Chubb, and you're obviously, I imagine, a fairly frequent drafter of arbitration clauses.
Naturally, James.
How do you deal with the question of the law applicable to the arbitration agreement currently? And will that change in light of the new proposed reform?
So, look, I think it's going to depend very much on the counterparty on the contract, right? Let me just say that at the outset. In light of the current steer of the Supreme Court, though, I think one would be turning your mind to the question of, do I actually need to draft in an express clause that governs the law of the arbitration agreement? But what I will say, and this is really why I would very much welcome this change that the Law Commission has introduced, James, is you've got to remember that each one of these points is a point of negotiation, right? And so my business colleagues are very often negotiating these contracts, but they already have to make sure that they've got the seat that I would like. They already have to make sure they've got the arbitral rules. It is just yet another point of negotiation to otherwise complicate the disputes clause. So actually this clarification would help enormously with that. People often call this the 3 a.m. clause, the sunset clause. Everyone's heard it. It's not disproved by my joining this call at a slightly early hour.
The 6 a.m. clause.
Yes, quite. But we really want to be in a position where we are minimizing the need for negotiation. And so I think this clarity helps with that.
So, and there's an interesting question here that we've been considering is whether one would cease to provide expressly for a choice of law for the arbitration clause if this reform goes ahead. So is your view that this is one less thing that you would need to worry about when drafting an arbitration clause?
I think probably yes. And again, I mean, it really is going to come down to the counterparty, the jurisdiction where enforcement is going to be sought. Those are all part of the consideration and the extent to which you want even more belts and braces. Of course, as an arbitration practitioner, we would always want as many belts and braces as we can possibly wear. But this is going to be weighed up in the context of a commercial negotiation. And you always come down to the points. What are the critical points and what are the nice to haves? And that is the conversation I'm having with a business colleague. And he says, okay, but if I only have one thing to give, what is it? And so it helps with that discussion when my list is not 6 things, but I can really start to focus on the 2 or 3 things, with that statutory clarification in my back pocket.
I mean, one observation, and Jelita, I may try and bring you in here. I hope this isn't a surprise. Is that the approach that is being proposed for England and Wales now is not the same as the approach that has been taken under other statutes around the world. So, for example, as I understand it, if one looks to Hong Kong, that doesn't follow the proposal that the law applicable to the arbitration agreement should be aligned with the law of the seat. I mean, and I wondered, Jelita, if you have a perspective on why Hong Kong has taken a different route and whether are there any lessons for England there?
So I think, James, I mean, first of all, that's correct. I mean, the first distinction, of course, is that if this provision is added to the statute books in England, then it will be different from Hong Kong and Singapore in the sense that there's nothing on the statute books in Hong Kong or Singapore on this point. So there's certainly not the same level of clarity. And it has been, I think, particularly in Singapore, a point of some debate, which I can come on to in a moment. But in both Hong Kong and Singapore, there have been a number of decisions which support what I think is described as the matrix law of the contract, or effectively the law governing the rest of the contract as the law that would typically be adopted for the arbitration agreement if the parties make no provision for a law to govern the arbitration agreement or the arbitration clause itself. And so I suppose the first point, of course, is as Nathan also expressed it, that the default will always be to adopt whatever the parties have expressly said. So that at least is consistent, I think, across all jurisdictions and indeed across this proposal. In Hong Kong, it's very clear that the matrix law would be the next port of call if there is a governing law provided in the contract for the rest of the contract. And I think that has typically been justified on the basis of party intention, that the parties intended that all their obligations under the agreement, including their separable obligations under the arbitration agreement, would be governed by the same law. And in Hong Kong, if you didn't provide for any governing law of the agreement, then in fact actually the seat then is viewed as the seat law is the right one to apply, because there is because that is the law with the closest connection to the arbitration agreement. In Singapore, that has been a really vexed question, because the law was very clearly laid down that in the absence of an express choice, the implied choice of law would normally be the matrix law, as we've just discussed. But there have been decisions most recently where the court was concerned about arbitrability of the matters submitted to arbitration under the arbitration agreement, and for that reason adopted the law of the seat, namely Singapore, which, as Nathan and Chantal have both mentioned, is more supportive of a wider range of arbitrable matters typically in the seats like Hong Kong, Singapore, and London than in this case the matrix law of the contract, which was Indian law. But in the prior case in Singapore that set down the main tests, actually the court decided to adopt the matrix law of the contract, even though it resulted in the invalidity of the arbitration agreement, which one would normally think was never going to be the party's intention. So this remains quite, as I say, quite an unpredictable area. And in that sense, I can see, particularly from the users or the business, commercial parties' perspective, it does help at least to have clarity, even if ultimately that may result in some difficulties, particularly I think on the enforcement side, if there were to be any challenge around either arbitrability of the matter or something of that kind when the award, even if it had been supported by the law of the seat, was brought to another jurisdiction. Thanks.
Just one more question, I think, on this proposed reform, and Costa, I don't know if you have a view on this. So it is proposed that this reform would only apply to arbitration agreements entered into after the date of the Reformed Act. And that would leave us in a position where we would effectively continue to observe the ENCA regime in respect of those many arbitration agreements entered into before the Act, which are going to be the subject of arbitration in the years to come. And alongside that, we deal with the reformed regime as well. I don't know if you have a view on that. I've certainly seen that as a question that's caused some debate since the final report was published.
Yeah, no, I can see that. I think the question here is of certainty. I think going back to what Chantal was saying, that the users of these agreements, of these laws, require certainty. And we talk about ENCA and Chubb, complex, unpredictable, and Nathan was right in the Law Commission report to say that that's just not right for our users. And I always look at it from the perspective of the users who we're trying to sell to, and not just in relation to our own legal practice here in England, but generally to make it more common sense and efficient. So here, I think I'm with the Law Commission. I think you need some certainty. I can see the benefit of having an immediate effect to get around ENCA and Chubb, but to balance against that is to balance the fact that we want certainty, and I think certainty is better if you have the proposed reform, which is to amend and have the act effective in relation to arbitration agreements agreed after the Act becomes effective. So it's in line with other new acts like the Insurance Act. I do a lot of insurance. Policies only are affected by the Insurance Act, i.e. August 2016. That's when it actually becomes enforceable, and it relates to policies incepting and being agreed after that date. So at least you then know what you're dealing with. So I actually agree with the recommendation.
Could I offer a comment on that, James,
yeah,
which I just interesting, perhaps even as an outside of jurisdiction observer, which is if the purpose of the reform is to clarify an outcome that might otherwise be uncertain, why wouldn't you adopt it as soon as possible? And in this particular reform, the issue is that the state of the law, nobody would have drafted for ENCA, you would think. People would not, if they thought about it, they would put in a specific and express provision. Right? It's not as though they're relying, you would think, on the ENCA outcome to be applied to their case. And so if a particular outcome is more predictable and certain for all parties, then it would save you having the contest over how ENCA and Chubb applies to the specific provision that you've drafted, even if you drafted it before this reform came into effect.
I'm mindful of the time and the other subjects that we need to move on to. Maybe Nathan, just finally, I mean, I think there sounds as though there's broad support for the principle of the reform there. The only comment is on this timing question. Why did the Law Commission adopt the approach set out in the final report? That is, that it would only apply to agreements entered into after the date of enactment.
There are two commencement provisions in our draft bill. There's the one relating specifically to Clause 1, and then there's a sort of general commencement provision in Clause 17. And Clause 17 is just a placeholder clause because it's not for the Law Commission to take decisions on commencement generally. That is for the sponsoring department. Clause 1 was the only substantive change to the law rather than sort of mainly other procedural changes. So it was just put in there on the basis that usually it should be prospective. But there have been debates about whether it should be totally prospective or whether it should apply have a retrospective effect. The leading alternative contender is that it would apply to new arbitration proceedings, but to any arbitration clause. And that is a matter for the sponsoring department to consider. That is the Ministry of Justice. They are currently considering it. Anything that is going to have retrospective effect also has to get the permission of the law officers in the United Kingdom. So that means the Attorney General, and it needs political sign-off from the ministers as well. So there are discussions going on about these questions, but there is no resolution yet.
Thank you. Let's move on to something different, and we're going to turn to section 67 now. I appreciate, Nathan, that there are a number of aspects to the Law Commission's proposals with respect to challenges on the grounds of jurisdiction. I think the most interesting one is the question of review or rehearing. So let's focus on that. What is the Law Commission's proposal in this regard, and why?
So a party can challenge an arbitral award before the court under section 67 on the basis that the tribunal lacks jurisdiction. We are primarily concerned with the circumstance where a party has already made that challenge before the tribunal and the tribunal has ruled on its own jurisdiction. In those circumstances, we recommend empowering rules of court to provide that there should be no new evidence or arguments before the court which should have been put before the tribunal, and that evidence will not ordinarily be reheard. This will discourage an application under section 67 from being a full rehearing. We think that would be more efficient, and we think that it strikes a fair balance between what is otherwise the polar positions of the parties. Back to you, James.
Thank you. Costas, do you want to kick us off on this one? So Nathan said it seems, a fair middle way. What do you think?
I think that it's quite revealing that the new proposals and new reforms obtain an extraordinary measure of agreement by all the commentators. I mean, the reports on section 67, the question of review or appeal or a hearing were very short, so most people have supported them. I think that they are, I was going to say a light touch, but they are good. I think there is a fudge, and I'll talk about that in a minute in relation to the way it's been put to the Rules Committee. I think that's a bit of a fudge, and I'm not quite sure why that happened, but it has happened. I think that's giving too much discretion. I think also, and I can see why they put in this exception that if you can have a full rehearing if it's in the interest of justice. But again, that's a bit of a loophole. So you've got those 2 points. But the nub of the matter, I think the Law Commission has dealt with it well. I think it's absolutely right. Going back to what the points we made earlier about arbitration users certainty. The nub of the matter was the Dalla case, again dealing with a case with case law and resolving it and giving certainty and clarity and moving things on where Dalla wasn't particularly liked in relation to making it clear that you would have a rehearing, a full rehearing, if there was a challenge to the decision of an arbitral tribunal in its jurisdiction when a party was applying for that. So I think the other interesting thing is that we mustn't forget that this principle, effectively competence, beloved by German practitioners, was introduced in the 96 Act. Mustn't forget that. So we're now talking about this and discussing it, but this is something we now become very comfortable with. So in relation to section 67. So I think that overall, I think it's absolutely the right way to go. I think having a rehearing isn't appropriate. This is having a review of the award, no fresh evidence or objections allowable unless unavailable previously. I think that's all sensible. So I'm very much in favour. The only thing I would add to that is the fudge. So it'd be nice to hear if Nathan probably doesn't like my description, but I think I can only describe it as a fudge. I would say that the other refinements are, again, I think necessary, and I think describe the way the Law Commission has approached this, a light touch, changing things. We haven't got Arbitration Act 2023. I think that's really significant. So I think the interaction with Section 103, Section 103 has been left as it is. I think in relation to enacting all the Article 5 New York Convention provisions for the enforcement of foreign arbitral awards, I think that was absolutely right. Interaction with Section 32. You didn't deal with these, so I won't go into some detail, but Section 32, the remedies available, cost consequences, we can go through that later, but I think that was all sensible. It's just a fudge I didn't like.
Nathan, I think you're entitled to a right of reply. I think the specific suggestion is that, I mean, maybe, is it, are you saying, Costa, that the buck has been passed to the rules?
Yes, I think the buck has been passed. I think they should have been, the buck has been passed to the Rules Committee. I mean, effectively the White Book, which can, you know, the argument is that things can change in the future, but things can change, there's no certainty, and where are we? And that's the whole idea. So I think that's predominantly where I say the fudge. I'm sure there are reasons, and Nathan will no doubt put me in my place, but for me as a practitioner, that sounds like a fudge. And also this loophole I mentioned earlier, I can see something's in the interest of justice and we have a full rehearing, but I can see lots of very clever lawyers playing with that.
Nathan.
So I think we would say that law reform and legislation is a practice of compromise. And one of the challenges that we faced on this was trying to find a middle ground between two rival camps who both felt very strongly in favour of their position. And any middle ground is going to see like something of a fudge to both camps at the end. But if it means that we can get a solution that most people support with more or less enthusiasm, then it enables us to make progress generally. What we didn't want to do was, once the issue had been raised, we had to consider it. We didn't just want to ignore it and say, well, this is a headache. We've tried our best to reach a solution which does represent progress. It will please some more than others, but there is a strong majority support for us doing what we've done. As for the origins of passing it over to the Rule Committee, I don't think that we've passed the buck there, because we have given it a lot of thought and a lot of consultation, and we've come up with very specific proposals. And if the Rule Committee were to adopt our proposals, I don't think anybody could criticise the Rule Committee for doing that. So it's not that we've said, you work it out. We've said, this is what we would do if we were you, but we're not you. So we've got to allow you your autonomy to consider where you go with that. The origin of moving it over, I know that there are some judges who have commented on the fact that it's now over to them to take our recommendations forward. But the suggestion originated from the judiciary as well. When they were talking about their case management powers being sufficient, our concern at the time is that case management powers are discretionary, and we wanted something that was mapped out so that everybody would know where they stood, that it wouldn't be a case-by-case basis, we'll see how we feel. So that's where we've tried to go, is to say, well, the judiciary are going to be more receptive to this reform if it's part of their case management powers, but we felt that it needed to be clear and there was a proper structure, a proper steer in place. So trying to bring all that together, we've ended up where we are. We would call it the practice of compromise. But you know, I live in Devon. Fudge is all right. We like it down here, so that's okay too.
I think we're all thinking of fudge at the moment. I mean, I guess one observation from me is I don't think it's unprecedented, is it, to include case management powers such as these in the rules of court. One already sees the power of, you know, summary disposal of manifestly hopeless Section 67 challenges. Not even in the rules, actually. That's in the Commercial Court Guide, isn't it? So this is a step down a road that has already been taken in that sense, I think. I mean, one question in my mind, and I mean, Chantal, I don't know if you've ever had the misfortune to be caught up in Section 67, but let me ask, you can always say you haven't been, but let me ask, is how far this is actually going to change things, or whether it's really just a clarification of what the sort of thing that one would expect to see under Section 67 already.
Yeah, no, James, I think that's a fair question. And look, at the start, I think the Law Commission has reached a pragmatic middle ground on this. Whether it makes much practical difference, though, I think remains to be seen. I mean, the Law Commission in their first consultation, consultation paper said, I think Section 67 is only invoked in a tiny percentage of cases. So that is your starting point. And then from what I understand, actually within those numbers, the number of cases where you actually have a full rehearing are really, really low. So I think practically speaking, I'm not sure it's going to have that much impact. We already know that Section 73 covers the point about not being able to put forward new objections. But, I always, as a user, come back to the fundamental question of cost and timing here. We need practitioners to remember that arbitration is a means to an end and not the end in itself. And so I think anything that expedites these kind of considerations are positive, rather than having to do a full rehearing of something the tribunal's already heard.
Jelita, can I just bring you in here? I mean, this is a debate that's not unique to England and Wales. And I wonder if, you have a perspective on how it's playing out in Singapore, for example, where from what I read from afar, similar issues arise when challenges to jurisdiction come before the Singaporean court.
So all challenges to jurisdiction in front of a Singapore court, and the same is true in Hong Kong, will have been to the tribunal first. So we have no provisions in Singapore or Hong Kong for direct access to the courts on jurisdiction. All applications must be made to the tribunal first. So you would always have a Section 67 scenario where you've got a prior tribunal decision, and both jurisdictions are quite committed to de novo rehearing of those matters. And there's a very recent case from August, I think, in Hong Kong, actually, where the courts reiterated the extent of their ability to take into account new material, new arguments, hear witnesses, the whole hog, as you might say. And I can certainly see that I think jurisdictional challenges are probably much more common in Hong Kong and Singapore than they might be, based on Chantal's indication of numbers in the UK. They are a common tool, I would say. And but challenges to the courts, I suppose, would be more limited than those which are made before the tribunal, obviously. As I say, the court, particularly in Hong Kong most recently, has been very robust about this. But I suspect that particular case probably would have fallen within the caveat that was described earlier, namely where there was a specific interest of justice. In that case, there was a genuine dispute over whether the main party to the arbitration, one of the main parties to the arbitration, was even a party at all, on the basis that they might not have actually signed an agreement, etc. And there was new evidence undermining the role that they had played as a contracting party, let alone, in the arbitration itself. So I think in that kind of situation, you might find a way around to an exception for rehearing in that circumstance for new information. But I would say that, the courts are quite broad in both Singapore and Hong Kong and open to hearing additional material. In Singapore, there are conflicting cases over whether or not you have to demonstrate that there was a special reason why your evidence was not before the tribunal at the time when they made their decision on jurisdiction, but certainly then the court is not prohibited from admitting that evidence. So it's definitely a more fertile ground, it sounds like, after this reform is implemented in the UK, in terms of things that might take the parties off in another direction for a period of time, to the chagrin of those who are actually looking for their commercial solution.
Interesting. Let's move on. So our next item on the agenda is the new power of summary disposal. And Nathan, could you kick us off again by describing what the Law Commission's proposal is and why it has made it?
So we recommend providing expressly that the tribunal can issue an award on a summary basis in respect of issues which have no real prospect of success. This is unless the parties agree otherwise. The procedure for such a summary award is for the tribunal to decide in the usual way after consulting with the parties. We think that this new provision has the potential to reassure arbitrators and enforcing foreign courts that summary disposal can be fair and appropriate. The threshold, no real prospect of success, aligns with that tried and tested in domestic court proceedings.
Thank you. And so Nathan, just on the procedure, just to clarify, so there would be a first question as to whether there should be a summary disposal process. And if the answer to that was yes, then the tribunal decide on the question, on the test of real prospect of success, whether that application should be allowed or denied. Is that right? There's sort of two stages to it.
Yeah, so in court proceedings, a party has an absolute right to stick in an application for summary judgment. If they lose, they get penalised in costs. Under our proposals, they don't have an absolute right. They can ask for it, but it's then in the discretion of the tribunal whether to accede to the application and go down that route, or say, you know what, there are other we can do you know, some arbitral rules have a short form arbitral process, or they might say, we'll hear a preliminary issue or something else. So under our proposal, the tribunal will still retain the discretion to pick another process if it thinks the other process will be better. But once the application is made, if the tribunal thinks, well, yes, at first glance, this looks like something amenable to a summary determination, then it will say, now we need to pick the procedure. Again, in court proceedings, the procedure is one size fits all, and it's laid out in the civil procedure rules, but not so in arbitration. Each case will be different. So the tribunal will decide what procedure we're going to adopt to get there, and it'll discuss its choice with the parties before it chooses the procedure. Then it'll go down the procedure and make a summary award or not.
Great, thank you. Jelita, what do you make of this?
So I think what's most interesting to me about this proposal is the perceived need to support arbitrators to adopt these processes. And whilst, of course, I very much appreciate and have experienced, both as an arbitrator and as a counsel, the reticence of arbitrators to be too creative with process, particularly in a way that short-circuits parties' opportunities, may appear to short-circuit parties' opportunities to be fully heard. I think that this issue arises much more rarely certainly in Hong Kong and Singapore, because the leading institutions all provide for this kind of mechanism in their rules. And I've most often seen this issue dealt with more in the context of the availability of this option within the rules, and for parties who are looking to a shorter route home on the grounds that the other side's case is completely without merit, leaving aside the question of which precise test applies, the parties can access these options within most of the institutional rules that are used typically within Asia in the major centres. So it has been a sort of source of competition amongst the institutions to see how aggressive your rules could be to provide for the quickest possible procedure. And for example, the SIAC's new draft consultation makes the timelines even shorter than they used to be. I think it's down to 45 days from 60 or something like that. So everybody is rushing to show that they could get you an answer or an outcome for your dispute more quickly if they could. But obviously, if from an empirical perspective, this is perceived in English or London-seated arbitrations to be a challenge, that arbitrators are reluctant to adopt more creative processes, then I can see that it would be helpful to provide for that. As I say, the process actually is quite similar to what we see in the institutional rules that prevail most often in Hong Kong and Singapore, in the sort of two-stage consideration, as you described, Nathan, and sort of timelines that apply to those two stages of the process. Maybe just touching on the test, very interesting to be aligned with the courts rather than with sort of the universal arbitral tests around manifestly without merit or manifestly without legal merit. Both Hong Kong and Singapore's leading sort of international but country-based institutions, so the HKISE and SIAC both provide a manifestly without merit type test. And having just been through one of those applications recently, it's an extremely high bar, and I actually think that no real prospect of success would have been a lower bar than manifestly without legal merit. There was quite a lot of debate over just how high that threshold might be and what might need to be demonstrated to eliminate a case on that kind of ground. But there's no doubt that I think that users of arbitration want to have unmeritorious cases efficiently and proactively handled by a tribunal. If this provision in the statute, rather than relying on specific rules of an institution, will facilitate that, I can only think that that's in the interests of both arbitration, obviously, and the users.
I mean, the test is certainly one point to discuss, I think. I mean, my understanding is that the original high bar, manifestly without legal merit, that one has seen across, you know, ICSID, SIAC, LCIA, etc., was set at that high level because of due process concerns, that unless it really was obvious that the case was hopeless, it might be said by the losing party that it hadn't been given its reasonable opportunity to be heard. I would agree with you that no real prospect of success is a lower bar. I mean, does that cause any concerns that it might be dangerous to use the English statutory process? It might lead to enforcement challenges and so on and so forth.
Is that directed at me again, James?
Yes, sorry, I didn't say. Yes.
Not at all. No, I just wasn't sure if others wanted to chime in on it. I mean, of course, the benefit of having it laid down in the statute is that would be the governing law of the arbitration, and so there would be a clear basis on which that test had been applied. And I think that is the same basis on which whichever test is applied under the relevant arbitral rules becomes then the threshold by reference to which the question of proper hearing is adopted. There is always room. I mean, any party, there will always be room wherever something has been rejected, even if it's just a shorter time to cross-examine a witness. Might be challenged as a procedural basis for an award to be set aside. But I would have thought if the test has been explicitly or expressly included, then that provides a stronger defence for assessing the case by reference to that standard.
So, Chantal, I mean, this has been characterised as a user-friendly proposed reform to the Act. As a user of the process, I mean, do you view this as a positive development of real practical value?
Yeah, I do. I do, James, and there are a few reasons for that. One of them is just, we've spoken numerous times about commercial certainty here. The Law Commission, I thought it was a notable phrase in their paper where they said arbitrators probably have an implicit power. And of course, as a user, that immediately makes me go, oh, how certain is it? Now, I'm aware, of course, that the arbitral rules apply this, it's there, but I really see this as, codification lending further weight to the statutory dismissal. It's just a further strengthening of something, and it's fine if it already exists, great, but actually I think just strengthening that can only be helpful. One of the other things, Jelita spoke about the reticence of arbitrators. I think that's completely fair. We are all well versed with the concept of due process paranoia, and people will have different views on the extent to which that is in play. But I would really hope that codification emboldens tribunals to summarily dismiss cases that are vexatious, unmeritorious, etc. That's really reassures arbitrators. But also at the enforcement stage, like Jelita said, the fact that it's codified, I would hope lends additional weight if those awards are subsequently challenged. So overall, yes, I think it really has got a very practical impact. In terms of the test, given that I feel like I'm more likely to face a vexatious claim than to be a vexatious claim, and of course I'm entirely biased, I can see the value of a no prospects of success threshold, which is slightly lower.
And Costas, what about your perspective as counsel? Do you view this as a practically useful addition to your toolkit?
Yes, very, very much so. I think there is due process paranoia. I think whenever we talk about arbitration, we always have a question in many conferences, arbitration versus court proceedings. And the cost, is it cheaper to have an arbitration than court? And I think we have to use these tools, and they have to be embedded in our Act, that you can have summary dismissal, you can have summary disposal of cases. I think it's very important. And I think the process, there is due process paranoia. I think the process proposed, this two-step process, is sensible. I think it gives the arbitrators and the parties an opportunity to consider why they're doing this. I I think it's very important also to have a higher bar, in my view. From my experience of arbitrations, I've often seen tactical summary judgment applications where they sometimes ask for all the claims to be struck out, to be summarily dismissed. So I think it's a good proposal, very much so.
So, Costa, on that, the two-stage process, I suppose one question which I have heard asked is whether by the time you've gone through 2 stages, you will have saved much. There's a concern that it adds sort of bureaucracy to the process. And I wonder whether you have a view on that.
I can see that. I think there's nothing better than trying to get arbitrations moving faster and not slowing them down, of course. I think the concern is from my own experience, having seen tribunals many occasions being overly cautious, delaying matters, increasing costs, that I'm very aware of that. But I think in this case, you have to balance it with potential challenges that you know, the parties say, well, why did they order that? You know, I'm not given a reasonable opportunity to put my case. So I think on balance, I think it's the right thing to do at the moment. But obviously we need, like with all these things the law commissions look at, we mustn't be complacent.
I think we've got time. I'm going to move on again. I think we've got time to briefly consider the question of confidentiality, which was a point on which the Law Commission chose not to recommend statutory reform. Nathan, would you mind explaining why the Law Commission chose that course?
We do not recommend any legislation about confidentiality in arbitration. While commercial arbitration often prescribes confidentiality, this is not the universally consistent approach across all areas, even of commercial arbitration. And in other areas of arbitration, there is a tendency towards transparency rather than confidentiality. We concluded that one size did not fit all, and that legislating would be too blunt and at risk of becoming out of date. Meanwhile, if parties agree that their arbitration is confidential, that simple agreement already provides the maximum protection available under English law.
Right, I'm going to freestyle it now and ask the whole panel if anyone differs. Let's put it that way. Does anyone disagree with the Law Commission's proposal not to legislate, not to codify, I suppose would be the way to put it, the English common law duty of confidentiality in arbitration?
I don't know if Chantal wants to go first, but I'm disappointed that this didn't happen. The amount of times I've advised on confidentiality and whether it's what is and what isn't confidential in arbitration proceedings to clients, it's quite regular. And I would have liked something to, I mean, codify sounds really sort of severe. We're codifying something that should be left to more discretionary. But I think here, you're basically, if you ask a user, they're saying, what are the documents, are the information, are we referring to things in the hearing, are they confidential? Is the contents of the award confidential? I think there should have been some way of putting some structure in place that actually makes things a little clearer. I'm a bit surprised that wasn't dealt with.
Chantal, did you want to say something as well?
I'm going to take a slightly contrary view to Costa, actually. I'm a little bit of the view, if it ain't broke, don't fix it. You know, I think the Law Commission concluded that it was working fairly well. That's kind of been my experience as well. And so where I am is really, I'm content for that development of that law to be, you know, left to the bespoke arbitral rules in the courts. And I haven't seen masses of issues at the moment where I don't think it's working. And so, yes, James, that's where I am on it. Of course, it's always open to the parties if they want to include some further provisions in their contract on it. But I see Nathan's point about using too blunt an instrument. Remembering, of course, that we have not updated, you know, the Arbitration Act is 1996. An awful lot of time has passed since that. A lot has happened. I think many will remember it as the year of the Macarena, James. I'm sure you do. But you know, a lot has happened. And I think actually being able to leave it to the arbitral rules, which are refreshed more frequently, is probably an acceptable outcome.
Jelita?
Yeah, sure. So interestingly, in Hong Kong and Singapore, just to provide the sort of comparative perspective, in Hong Kong, confidentiality of arbitral proceedings is enshrined in statute. So there are very specific provisions around the limited bases on which disclosure can be made around the details of any arbitral proceedings, etc. In Singapore, under the SIAC rules, that's all provided for in the rules themselves, so you wouldn't need to think about it for your agreement. So in both of those jurisdictions, under most provisions or most situations, you wouldn't need to consider dealing with it in the agreement itself. Interestingly, Singapore amended their statute just last year, amended the International Arbitration Act just last year to move from a position where court proceedings in relation to arbitration from the standard position had been that you could apply to have those proceedings in effect anonymized. And Singapore is a little bit famous for having all their cases made up of alphabet letters so that you have no idea about all the parties. Very difficult for all of us to remember the precedents when wanting to cite. But they moved from that one slight step further, which was to say that proceedings were by default to be anonymized. And so there was no need to make a specific application for that. You would make the application for the converse, i.e. for publicity or non-confidentiality of those proceedings and non-anonymization of the parties' names. Try saying that quickly. So the rules as Chantal sort of says, that I think there is an assumption in most cases that you will be covered by pretty strict confidentiality, and there's case law in Singapore to say that there's an implied obligation of law in relation to the confidential treatment of arbitral proceedings. So it's interesting that there was a real concern about making that more explicit in the UK.
Yes, and I mean, on your point about the openness of court proceedings, I think there's a similar trend in England, actually, and we see that, for example, in what the Supreme Court said in Halliburton about naming arbitrators who are subject to challenges. Just to chip in myself, I mean, a question for Nathan, I suppose. I mean, I was slightly surprised, I suppose, yeah, slightly surprised by the conclusion that it was not possible to define the English duty of confidentiality at common law. I mean, I thought it was sort of essentially as set out in the Emmett and Wilson case. I recognise that different standards of confidentiality apply to different types of arbitration, and I wondered whether one model that the Law Commission had considered was effectively an opt-out regime whereby there is a statutory default that reflects the current common law, with the flexibility of users and industries to contract out of that in their rules or their arbitration agreements.
I think one of the problems with an opt-out is that people don't. And so your default rule becomes the rule. And then you've got a rule of confidentiality across all types of arbitrations, including types of arbitrations where it's not suitable and the people involved simply won't have considered it. So, family law arbitrations, sports law arbitrations, but we always know when a sports person is being subject to an arbitral dispute. So these sort of areas, default rules have a habit of becoming just the rule. As for defining what the actual common law test of confidentiality is, the challenge is that it is the complexity. So it can arise in contract, it can arise in equity, it can arise in tort, and each of them are formulated in a slightly different way, have a slightly different reach, and have slightly different exceptions. So it's not beyond the wit of a good lawyer to come up with an exhaustive account. But an exhaustive account in practitioner texts take chapters, many chapters. What's quite interesting I found when reading other statutory provisions like in Hong Kong or in Australia is you get to the end of them and they're quite a slog to read, and they're not the same as the common law, and they're not the same as each other. And there's a danger there that you just end up putting in a default rule that seems really nice and simple for, let's say, ICC arbitrations, but just causes a real headache in how it fits in with the rest of arbitrations and the laws of confidentiality more generally. And as Jelita says, if the SIAC have it mainly in their rules, actually you get them in the rules of arbitration seated in London as well. And if a particular sector wants to put it in their rules because they know it works for their parties, fabulous. And that's probably the easiest way for it to be addressed.
Well, I'm pleased to say that you have support on the chat for the Law Commission's proposal. So I think you win the day based on that limited survey. I'm mindful of the time. We're coming to the end now. I think it would be helpful if we went back to you, Nathan, to conclude matters. To summarise what happens next. You've produced a terrific report, which essentially has very broad support. There seems to be substantial consensus behind the very large majority of the Law Commission's proposals. What happens to this fantastic piece of work next?
So the report has been laid before Parliament, which just means that a copy has been given to Parliament. This is what we have to do with all of our reports. It's now with government to decide whether or not to take forward our recommendations, whether or not to accept them, and if so, whether to make a legislative slot available. We don't know whether or not we will get a legislative slot until the King's Speech, which is on the 7th of November. Nobody knows until the King's Speech. And even if I did, I've been told I'm not allowed to preempt the King. So we won't know, but genuinely I don't know. So we're all waiting to see. It's looking promising because there is a wide level of support. It's a technical bill. It's not party political controversial. You know, we can debate the merits of these technical points, but it's not as though the government want it and the opposition will argue it. So that also means we might be able to invoke the Law Commission special procedure, which you can invoke once per legislative session, and that means essentially that is an additional slot to the time available for legislation. So it means our bill wouldn't be competing with other bills, it would be additional to it. And that's a good thing because 2/3 of legislative bids do not find a slot. There's that much legislation people want to do and that little time to do it. And of course, this is our final legislative session before a general election. So anything that starts has got to get finished because there's no carryover. But it's looking promising. The Ministry of Justice, our sponsoring department, is preparing as if it's going to get a legislative slot. So if we do, we will hit the ground running. Fingers crossed for the 7th of November in the King's Speech.
Indeed. It seems to have overtones of 1996 all over again. I mean, let's not take that parallel too far in case it gets controversial. But
or in case we start the Macarena.
It's 1 minute. It's 1 minute to 1. I'm hoping Guy is still on the line somewhere. And Guy, I believe you're wrapping up.
I am indeed. Thank you, Nathan, Jelita, Chantal, Costa, for your contributions. Particularly helpful, Nathan, to hear the potential direction and whether it will make it into the King's Speech. We know you don't know at the moment, and if you stop saying you don't know, then we have to assume you do know, but you won't be able to tell us. But we can all hope that we might get through under some sort of special procedure, which will be very fitting for special arbitration lawyers as well, as you all are. James, thank you very much for moderating this excellent panel. It's been really good. I will not attempt to summarize any of what's been discussed because it was all very, very clear. And can I thank all of you on behalf of all of the attendees. If we were in person, you would be hearing rapturous applause right now. So please imagine that as our participants clap in the comfort of their own rooms. For our participants who haven't yet diarised the next session, the final session of the conference will be at 3 p.m. today on renewable disputes. Please do tune in. Thank you, everyone.
Thank you all.
Thank you.
Bye.
Bye.